All right, well, good afternoon, everybody. Welcome to the Jolt-sponsored government speech and social media talk. We're just going to be talking generally about how social media is transforming politics and how it is affecting our everyday lives through government and how it is affected or is affecting our concepts of speech and what is speech. So we've got Joshua Morris and Professor Ryan Garcia. Why don't you take a second and just introduce yourselves to the camera and our adoring audience.
Sure. So my name is Ryan Garcia. I'm an adjunct professor here, and I teach social media law in the spring semesters. And then when I'm not doing that, I am an attorney up at Dell, where I support our marketing teams as well as all of our social media and community teams globally.
I'm JT Morris. I'm an attorney here in Austin. About half my practice involves First Amendment issues, and at any given time, most of that involves social media or other kind of internet speech. So.
Awesome. Well, we're going to start off with the easy question. What is a public forum?
So if we're talking about First Amendment, a public forum essentially is a place owned and controlled by the government that's subject to First Amendment protections for private speech made in that forum. There's different tiers of public forums, the first being a traditional public forum, places since time immemorial, since that we've traditionally associated with public discourse, parks, town squares, sidewalks, that sort of thing. Once you get sort of the tiers below that, and I will say, a traditional public forum, there's not much the government can do in terms of restricting content or viewpoint. They're basically limited to making content neutral restrictions, time, place, manner. They have to be, pretty, the nexus between the restrictions and an important government interest, and they have to provide alternative means for expression. Once you get sort of below that, the tiers become a little mushy, but there's sort of three other tiers. One is a designated public forum, essentially a place not traditionally held to be associated with open public discourse, but one that the government opens up to basically all kinds of public discourse. But after that is a limited, and those are treated the same as a traditional public forum. After that, you have what's called a limited public forum, which is a forum that the government opens to top speech from citizens on limited topics. And those, the government can make content-based restrictions as long as they're reasonably related to the purpose of the forum. But again, they can't engage in any viewpoint discrimination. After that, the Supreme Court has sometimes designated what's called a non-public forum, something like a military base, where the government can engage in a lot of speech restriction. But still in those, viewpoint discrimination is not allowed. When we're talking about public forum and social media, that's a question that's being litigated right now. We had Justice Kennedy declare in the Packingham decision from last term, the internet is the new town square, which made his fellow justices, at least a few of his fellow justices sort of retracted horror, and concurrence sort of chided him for saying that. I think he's right in terms of the non-legal aspects of it. There's no doubt that the internet is the new town square, and it's the international town square, quite frankly. But as far as the First Amendment, when he says that, I think a lot of people sort of said, well, is he saying that the internet is now a traditional public forum that's subject to First Amendment scrutiny universally? And that's sort of the question I think the courts are going to tangle with over the next years for a while.
Real quick before
Yes.
Professor Garcia gets into
I'm going to just agree.
Just so you understand sort of the idea of the format of this talk, we don't want to have them talk and answer questions and then at the end give you the opportunity to ask questions. We want it to be more of a conversation. So if anything they say sticks out, or if you need clarification, anything like that, don't hesitate to raise your hand, and so that way we can get everybody more involved.
And along those lines, the Packingham decision is just a fantastic one from the last couple of years. Not only because one, unanimous, which that's just not that common anymore on anything. The second was because, the only dissent, not even a dissent, right? We had three of the most conservative judges kind of file their own opinion saying, we agree with the legal reasoning, but all this other stuff just goes too far about declaring the internet a town square. That was the only issue, really, that Alito had, that the others joined in on. But this is, of course, the same Supreme Court that a couple years ago had a long time figuring out how pagers worked, back in the 90s. So I'm not sure if they actually disagreed with it or they just didn't want to figure it out. And their clerks tried to explain it and they just didn't get it. And so are they waiting to kind of analyze it, those three? Or I don't know. But either way, that was only 3. I mean, we did have 5, come down on this opinion saying it is the town square. And it really is. I mean, anyone who spends more than 5 minutes on Twitter recognizes that it's a town square with way too many people, that you don't want to be around, right? And so immediately you start kind of culling down your own experience, because if you were just exposed to that fire hose, you would run away in horror. But that's really what it is. And so it is the parks, it is those squares with all the different speakers, lobbying for their own positions and gathering their own crowds, but you are free to walk around. And it's amazing how this transition from physical to virtual and all the implications that comes with it really makes for some interesting conflicts. Like Lawrence Lessig's famous book on code versus code, where it's no longer about what the law is regulating, but what these platforms are actually enabling you to do, right. And then the implications that run in there. Are just fascinating, because we have so many decisions that we're dealing with, cases about what platforms are doing, how people are handling them, and a court could go through all of its decision and all of its analysis, and the next day that could be completely moot because the platform changes the functionality. They just turn off a feature or they enable a new one, and so now what? It's really a fascinating transition, but at the same time, it moves so fast. That's kind of scary for a lot of the legal systems in place.
Right. So would you say that in certain ways, you mentioned like the difficulties of these justices in grappling with how these websites and services function. Do you think that in certain ways that grappling is moot, and that they need to sort of confront the reality of how technology functions without sort of looking at the code beneath it to a degree?
That's tough. I mean, yes, because they need to understand the tech, but at the same time, understanding the tech then leads to this next choice where you understand it, and once you understand it enough, you realize that you won't understand it tomorrow, right. And there will be something new. And so how do you fit that into the way that you've been, our legal system's been working and applying codes in a way that now this will last us for a while, right? That may no longer be the case. I mean, a decision that we come up with, a law that we come up with, may be really, really difficult to apply in just a couple of years. I mean, one of the great, we have the CAN spam legislation to deal with, spam. Right. And that was it. We thought we kind of dealt with it. And then the first time that Facebook tried to deal with spammers, they used CAN spam. And a judge actually agreed with them and said, yes, CAN spam applies, but CAN spam has all these requirements that you can't use on Facebook. An unsubscribe link, you can't put that on Facebook, that's unfollow, right? How do you put a subject line when Facebook messages don't have those? Or at least didn't back then. So, already that's kind of growing pains. And Facebook, I think, realized it because they went through this whole legal battle, and at the end of the legal battle, they but a decision in their favor, good for them, but that wasn't nearly as effective as they just changed how the platform worked. And, they should know how to do that, they built it. But that makes, that's just difficult for Congress to write laws or state legislatures to write laws that are going to apply to the next platform, because we never know what that next one's going to be. That's kind of the point. So I don't know. It's tricky. Coming to grips with it means you have no grip on it.
Right.
Yeah, I mean, I think Justice Kennedy actually mentioned that in Packingham. He says, what's good law today or what's a good decision today is not going to be tomorrow because it changes. He says, we've been doing this since the mid-90s, and over the 2 decades from then, everything has just evolved so quickly. So I think it's a really tough job for legislators and courts to try to strike a balance between, applying good solid First Amendment principles, but also staying up with the technology and understanding how it works and adjusting those principles as you go. I mean, I think there's a danger on both sides when you sort of apply First Amendment principles that don't match the technology, you get funny outcomes. But if you get so hyper-technical that you sort of forget, and I think one example is what's going on in this lawsuit between the Knight Institute and Donald Trump over his personal Twitter account. where you see the court kind of struggling with how Twitter works, the government's trying to make this hyper-technical argument to sort of circumvent all these First Amendment protections. But when you look at sort of at least the front-facing platform of Twitter, I think any reasonable person says, yeah, this is kind of a public forum, right? This is interaction between a government official and people. So how do we balance out the technical aspects of it without sort of just overrunning First Amendment protection for private speech on these platforms?
So does it matter if the government official is trying to speak for the government or trying to speak for themselves? And does it matter how they represent themselves to the public on those platforms?
I think absolutely does. I mean, government officials, don't lose First Amendment protections just because they're government officials, right? You can speak personally, you can, speak to your personal beliefs. But, sort of in the case of Trump, where he's out there using his @real Donald Trump, now it's transpired into him tweeting out policy positions, things that people say, yeah, this is coming from this is colored sort of in the cloth of the office of the president. Yeah, I think it does sort of matter what they say, how they portray it sort of to the public. So yeah, I think that's the real heavy factual inquiry that courts have to look at when they're assessing these sorts of lawsuits and disputes.
Yeah, and they haven't had enough to really come up with a test. I mean, that was in the oral argument at Knight Institute, the judge even asked that, right? I mean, first, yeah, they're getting into the hyper-technical details. It's fascinating to go in, is this doctrinal prejudice, is this ability, and I mean, really, really hyper, which, maybe as a practitioner for First Amendment, you got, I was like, what? I don't get any of this, and again, it was also interesting to compare it to Buckingham, where the Supreme Court level, they didn't get into any technical details. They just said, speech, no speech, unconstitutional. I mean, it's one of the shorter Supreme Court decisions out there, so really fascinating. But, at least in this one, the judge even asked at oral argument, if someone is using their account in this mixed way, where is the line, right? Where if you're sending out some happy birthday tweets and you're also making official positions, when is the line crossed? So that now we're going to view this in its entirety as an official government action or government statement. And they don't get that far in kind of addressing that question, because as the plaintiffs kind of said was, there may be a line out there. Wherever we draw the line, I don't know, this won't get anywhere near it, right? Because you just look at the Twitter account and these are official statements, and you look at how everyone is treating them and their official statements, and he's not sending out half happy birthday messages, right? I mean, there's like 0 happy birthday messages, because I don't think he knows other people have birthdays. But
Can you say happy birthday to Putin or something like that?
oh, maybe to Putin. There's always the exception. But so, that is an interesting question, though, right, in terms of someone who is using it in a mixed way. And then it also is, who is the person themselves that's having these mixed messages, right? Even if it's a very high-level person at the National Park Service who's doing then mixed messages, right? Are you drawing the line further to one way or the other versus the chief executive of the country? And how much would they need to tweet in terms of personal statements before you're willing to say, okay, then none of the other ones matter? I don't know.
Yeah, I mean, even after the oral argument, the judge asked the parties to submit a letter brief asking, well, does the line get drawn, for example, at the official @POTUS Twitter account and the @White House account? The governments submitted their brief the other day, basically making the same sort of arguments that, well, the way Twitter works, it's not really a forum. They say it's not a forum because it's government speech, which is a whole other issue that will take us days to talk about if we were here for it. So the court's trying to find that line, but I think as Ryan notes, the plaintiff is just saying it doesn't matter here because it's pretty clear. Trump is making official proclamations. He's making statements on matter of public concern. People are, commenting, replying, supporting and dissenting viewpoints. That's the hallmark sort of creation and maintenance of what's a public forum. So even, putting aside the technicalities of Twitter, blocking versus muting, whether you delete your account and tweets stay up there, all these technical arguments that government is making to try and sort of get around it, it comes down to the fact that it's a government speaker, right? He's making proclamations about policy and official positions, and people are allowed to respond to it. And if that's the case, you can't engage in viewpoint discrimination. That's what the plaintiffs are arguing at least.
Yeah, and I mean, I don't know how this, this first level will happen. I see this going higher, but I don't see any way that it gets to the Supreme Court. And given Packingham and given their previous treatment of his tweets in terms of some of the immigration battles, I don't see how they come down anyway, but same as, similar to Packingham. I can't say same because that was a law, but, just, they're not going to engage in all this hyper-technical. They're going to say, guys, speech, just stop it. And yeah, the judge was doing a lot in terms of the oral argument, trying to point out that he could achieve the same results he wants by muting users instead of blocking them. And it seems that you avoid all these things. And he seems to be making some very heavy-handed comments in the oral argument, like, it would probably be a good idea for you guys to settle, and maybe he just mutes people instead of blocks people. Like, maybe then I won't have to make a ruling against you.
And I think the word she used was, why can't President Trump just use the muting function so he sort of looks like he's at least pretending to listen? So the citizens can see his comments, can reply to him, but he doesn't have to deal with
Alex?
So would it be a fair analogy to say, like, if a government official, during their off time was at a party, and they start engaging in a conversation with people at the party who start supporting everything they're doing, and then someone comes along and starts yelling at them for their positions, and they say, you know what, I don't want to talk to you, and they throw them out. Like, would that be a similar thing to what's going on with Twitter?
It's closer. I mean, well, here's the thing. That's the government's argument in this case, the Knight Institute case, is they are trying to, while the plaintiffs are trying to say Twitter is this public forum, the government is saying, no, it's like the president's at a party, and there are all these different groups, and so he's just wandering away to a different group in the middle of a conversation, which seems to me kind of like a senile old man, but so maybe it's directly on point, but I don't know, but that's the analogy that they're trying to go for, that, that's just it. He just doesn't want to engage in that conversation, and there's nothing forcing someone. Like, the First Amendment doesn't force you to listen to people talking to you, it just gives them the right to talk. And the plaintiffs are correctly pointing out that, well, that's more of what you're doing, right? There is a way to do that. That's called muting. What you are doing is you walking away, throwing them out of the party, and making sure that they don't hear anything that's being said. I mean, it's not even kind of that, if you wanted to use kind of a dinner party or a cocktail party analogy, to me, it's almost like some kind of Black Mirror episode where you actually get to push a button and they just don't, they hear everything else except when you talk, and suddenly it's just like nothing coming out, and the lips are even blurred so they can't read that. So it's just a strange kind of feature that, yeah, I mean, the analogy could be drawn, but that's where it starts to fall apart, right? Once you get to what the functions are and what they're able to do once they're blocked versus muted.
So would they be able to block people for any reason at all, or would the line that you draw be that they cannot block anybody?
Well, I don't think they can't block anybody. I think part of it is platform dependent, right? So, personally, I think if the government were to, it's hard on Twitter because you're so limited in space. Well, let's move to Facebook, for example. You have your about page and everything. If the government sets forth very clear details about what the page is for example, this is a government page. We're going to post about weather, road closures, and construction. And that's it, okay? And you have some, your local loonies getting on there complaining about taxes and everything else. I think in that case, they could probably block them because they created the forum for those limited purposes, talking about traffic, road closures, and you've got people sort of going outside the scope of that. The government might have a pretty good argument that they can, we created this forum for this limited purpose, we can block content that's not reasonably related to the purpose. As long as, of course, they did it in a viewpoint neutral fashion. Twitter's a little bit tougher because I don't know how you can sort of frame your Twitter account and your Twitter feed to be sort of limited, and you have like a very small section to describe what your Twitter page is about. So, I think the government has here to rely on the fact that either one, it's not state action because Donald Trump's speaking in his private capacity, and if it is state action, then it's government speech, which is essentially saying that, look, this is the government speaking, it controls the message, and there's a lot of other factors that go into that test, but because it's government speech, it's not subject to First Amendment scrutiny. I think that's a hard sell. I think the government's going to have a really hard time proving that, which is kind of why they're leading with This isn't state action, it's just Donald Trump's personal account. You know, if you want state action, go to the official POTUS page or the White House page, which they still say is government speech, but that gets a little bit closer. But yeah, I think it really depends on how we calculate what the forum is. You know, is this Twitter account a designated public forum because it's open to sort of all kinds of discourse on matters of public concern? Are we just limited to it? Is it limited to exactly what Donald Trump is tweeting about? I think that forum analysis is going to be, assuming the plaintiff can sort of overcome the lack of state action argument the government's making. That forum analysis is going to be really interesting to see what the court does with it.
I think it's, you know, it's just such an interesting path that we've taken to get to this conversation, because as my students will know, there's, you know, one of my favorite quotes was from a friend of mine where social media was not made for marketers. But that's where, of course, all marketers are, right? They're all on the social media platforms because that's where all the people are. So just as much as these platforms were not made for marketers, they certainly weren't made for politicians, right? And yet now we're getting into this area where government entities are setting up, you know, Twitter accounts and Facebook pages, and they are using this as their official form of communication because that's the best way to reach people. And corporations are doing it as well, and you've got regulations around that from the SEC as to how you distribute information. So I mean, there's no denying this evolution towards social media, and this is how we distribute information. And that's fine, and I think actually technology, the path of technological evolution pushes us that way as well. But this particular problem is actually stemming from all these social media platforms and their inability to deal with trolls and bullies and hateful speech on their platforms. Like they flung the doors open because they wanted these platforms to grow by any means necessary, so that then they could make a profit by some way that they're going to figure out eventually. You know, but when all of the hateful speech and hateful activity started happening, they had no way to deal with it. And so they started dealing with stopgaps as the more, you know, visible cases came up, cyberbullies, people killing themselves because of activities when they were pointed out, you know, all of these things. And the block function actually came from Twitter as a result of, they enabled the mute function first, but then people who were being harassed online said, yeah, but those people that are harassing me are still seeing all my materials, and I don't want that, and that's not right. So they said, okay, then we'll create a block function. You know, nothing about actually dealing with the people that are doing this bad activity, putting the onus back on the user to say, okay, you identify these people, and now you won't get to, you know, they won't get to see any information as long as you designate it. So now how that complicates all these other uses of it is tricky, because they just kind of, you know, toss the ball back over the side of the fence. And you know, I feel for the platforms, because they didn't create these platforms for political speech, for government statements, for government accounts. But at the same time, their inability to deal with some problems that, okay, they didn't create them, they didn't intend for them to happen, but unless you've had your head stuck in the sand for 10 years, you recognize it's a major problem out there. And so their inability to come up with more effective ways of dealing with it are now creating these other problems, right? I mean, I don't know what the final solution would be for them. I don't know if there is one. You know, personally, I would like to see Twitter, Facebook, some of these come up with some kind of standard that, I mean, it's not that they need to come up with a standard for the US government, because they're global, everyone's on them. But for example, on Twitter, Twitter has created different classes of users, right? They have created verified accounts, and you have non-verified accounts. And it seems to me that if someone has gone through the process of verifying their account, saying, this is me, I am using Twitter, I want people to understand that this is me on Twitter, then they're going to be using it for some forum, some way, right? I don't know what it is. If it's just to promote their books, if it's just to answer questions on a topic, if it's to make official statements in the capacity of their job, I don't know, because it's Twitter, it's wide open. But if they've gone through the steps to verify, it seems to me, maybe Twitter could just say, okay, then you can't block people, right? That's the trade-off. We are going to verify that you are you. We're going to put that special badge on you. But now, you can't prevent people now from looking at your statements, because you just told everyone, and you told us, you want everyone to know that this is you. Fine. No more hiding your statements from other people. I mean, that to me seems an easy fix that they could make. I'm sure that there are problems in terms of stalkers, you know, and celebrities who have people doing that. You know, quite honestly, I think there are a lot of those problems anyway, but At least if they did that, this case would go away. I don't think Twitter really cares if this case goes away because it's not directly impacting them right now. But I could see further cases down the road that does impact them, because eventually, like right now, this first ruling, there's a lot of discussion about whether they can order the president to unblock people or merely make a decision that says blocking people is unconstitutional and hope he follows it, right? And then if he doesn't, then come back to court, the next week and say, no, we meant it, right? But if you have more and more of these cases where it comes down to people are not following that rule or that law, then does it go to the platform, right? And then does the government then start to regulate the platforms because they say, because it is easier for us to regulate one company than it is for us to regulate the tens of thousands of people that work in government, state, local, and federal level.
Yeah, and that seems to be coming. I mean, we have, going back to sort of Kennedy's statement that, the internet is not this public forum, there was just a lawsuit that was dismissed, just the other day, out of the Northern District of California, where this plaintiff called Prager University make videos and content, purporting to teach people about U.S. civics as a kind of conservative bent. They sued Google because Google, who owns YouTube, had removed some of their content. Prager University sued under the First Amendment, saying that essentially Google had stands in the shoes of the government because YouTube is a universal public forum that they've basically held open to speech on all matters of public concern, and they should basically stand in the shoes of the government. It's still a suit when you think about it, and I think it's a very good thing the court dismissed it for a number of reasons, but eventually I think we're going to get to that point where we're going to see some legislature, either at the federal or local state level, try to start regulating these platforms to make sure that the government has a hand in what goes on there and what doesn't. And I think that's the real tricky part of all this. Before the internet, public forums, was easy. It's property controlled by the government. Now we have the government building pages and Twitter feeds on platforms controlled by private entities. How that works out, the interplay between that is really interesting, I think, and it's going to be interesting to see how that develops over the next couple of years.
So you mentioned YouTube, and I have a question that, I apologize if it's already been litigated, but so say the White House were to upload a video on YouTube and simply shut comments off, just turn comments off, because that's a content neutral discrimination. Is that something that's just A-okay across the board?
Yeah, I think so. I think that would, in that case, the government would probably have a good leg to stand on saying it's government speech.
Yeah.
Because they're saying, look, we're controlling the message before the message gets spoken, right? Once the message is spoken, right, then I think the government has a hard time sort of arguing around that they could be a limited public forum. So if they sort of control the comments beforehand and don't let speech at all, I think they have a good case to say this is government speech. We intended this to be our message only. And I think that'd be okay. I don't know if Ryan disagrees or not, but.
No, I'm good with that.
And then kind of going back to your earlier mentioning of possibility of using Twitter sort of as the government speech arm and referring people to the government's website, would the court then require some measure of interactivity on that website, some form of petition?
So are you talking about if, for example, people went to like whitehouse.gov,
Yes.
something like that? I think it's the same sort of analysis, right? If the government, creates a web page that doesn't have a commenting function, it doesn't have any interactivity functionality, yes, I think, it's a government message, it's government speech. The government isn't required to create a forum in a place it controls. But once it does open that up to private speech, the First Amendment's going to kick in at one of those levels of forum protection.
Will those First Amendment protections for citizens apply to people abroad as well? So like, could Trump block someone who's not a US citizen living in France? Like, would that be permissible under the law? Like, is there a requirement to allow some foreign citizen to come to a public forum here in the States?
It's a really good question.
Yeah, that's nice. I like that. You should write an article.
I was thinking.
Yeah, because are they a visitor?
Exactly.
Or are they, yeah.
Yeah, I mean, that's, that, you know, when I was talking about the transformation from physical to virtual, obviously the physical space, if they, you know, somebody from Mexico came to a Trump rally in Austin and, you know, started saying something and he was removed because of his beliefs, yeah, he'd be you know, he would be entitled to First Amendment protection. You know, they'll basically care about citizenship. But yeah, in the virtual world where somebody's, you know, tweeting at Trump from Botswana or, you know, someplace that's really remote, I mean, I don't know.
Russia.
Russia.
Well, and we've had, yeah, hypothetically. Well, and we've had, at least when it comes to social media and jurisdiction, we've had it go both ways already, right? We have had lawsuits where citizens outside the US have applied Twitter terms to say that US law applies, and so that's why we're going to use that. That was the Daniel Morel case, right, in terms of the photographs and his copyright in them. And then we have had lawsuits, for example, in France, that have been against Twitter using French law, despite the fact that Twitter terms say that US law applies. French courts have said, nope, you're doing business here in France, French law applies. So now, in that case, it was releasing the identity of certain anti-Semitic handles because anti-Semitic speech is illegal in France. So depending on the country, depending on the desired outcomes, we've already have conflict there, and as we know, there's no one court to kind of to figure out what the different countries' interpretations, which ones gets it right. So yeah, I don't know if we'll see an answer on that, but yeah, that's a good one. That's at least 30 pages. Notes.
When's it due?
Well, I don't know, Write-On is going on right now, so yeah.
Don't you graduate in 3 weeks?
Don't give them ideas.
Haley?
Pushing that a little bit further, so I've been thinking about bots, and so technically they're giving someone's viewpoint, but it's a little bit of AI related. So let's take foreign people, Russians, out of it. If it's a US citizen who's made a bot that's going to automatically respond, is that still protected under free speech, or is that just spamming?
That's a good paper too. It's a few pages shorter, I'm gonna admit. That's an interesting one. I mean, they have created the speech, this programmed response. Is it protected the same way?
Yeah, I mean, I think that's going to be an issue we're going to see soon too, right? Is AI protected under the First Amendment? There's certainly a speech element to it, right? But it's kind of, where is the line drawn between speech and just kind of pure, especially if it's a bot that's kind of spammy and it's more conduct related? Yeah, I don't know if that's going to come out.
Yeah, I mean, that's programmatic speech, which
Right.
we call software, right? That's what every piece of software written is then. So, does that then have the same protection? No. That makes it a little bit easier, but
even then, if you have a spammy bot, but let's say the spammy bot is just programmed every time every time Donald Trump says something about the wall, okay, the spammy bot sees it, he goes into the Twitter feed and says, no, you're wrong, support immigration, stop building of the wall. That's political speech, right? So, yeah, it's a bot, yeah, it's spammy and it's programmed to do one thing, but it's speaking a dissenting message that traditionally is protected, mostly under the First Amendment. It's a really good question.
I wonder if you could walk that back to be like, on Facebook, I know you're able to schedule posts instead of posting them. So if you scheduled it based on some other action, it feels more like the person's speech than anything. I feel like it'd be different maybe if it was like drafting its own post, like based on whatever the person said, with like no touch from the programmer.
But doesn't that seem even less speech-like? Then that's more like then that really is more like a bot. Just on the threes every time I say, this person sucks. Versus every time this person speaks, I respond back, nope.
Yeah, there's
yeah. Yeah, it's interesting. But even then, as I'm thinking about that, right? If you had just a standard programmatic response, is that really speech? Because what if they're saying something that you actually agree with, right? There's no analysis that's going on. And then even the Packingham decision was saying like the kind of central tenet of that First Amendment is for you to be able to speak and listen, think about it, and then go back and speak and listen again. Go back, and if it's automatic and programmatic, you've taken that equation out, you've taken the thought out of it. I mean, certainly you applied it the first time you created it, but in all the subsequent uses, it isn't there anymore. So it seems less to the core of what we're trying to protect with First Amendment.
But, and to get a little First Amendment nerdy here, and I don't mean to do that, but.
Why? This
sort
is
of,
the
yeah,
place.
right.
Come on, nerd it up.
But sort of, yeah, it's just sort of to play devil's advocate with that. When we think about, the First Amendment protects freedom of the press. Well, back when the founders put that into the Bill of Rights, freedom of the press meant freedom to engage in mass communication. So is there a difference between the printing press, right, that allows you to, make the same pamphlet, the same book, the same newspaper over and over and over, and a bot that lets you disseminate the same message over and over and over and over again? Cool. Something to think about. I don't know.
Yeah, little printing presses that are out there. Oh,
Yes.
that's good.
Yeah.
A lot of paper ideas.
Yeah. So many.
So you kind of mentioned this when you were talking about blocking users and muting users. Is there any sort of, do you see an evolution in social media platforms or in third-party platforms sort of forthcoming, or that you think is going to happen sometime in the near future that allows these government users and these public officials to create these messages and engage with people, with selected people, without sort of tripping the public forum wire?
You mean like email? Like, yeah. I think they've got that.
Texts.
Yeah, they can figure that out. Government officials have problems figuring out what's a direct message and a tweet. I think that exists, at least in terms of, to me, a limited communication is more of a one-to-one, more a one-to-few. And we've already had that in terms of phone calls, letters, now emails, and other phone calls. There's ways that government officials can more target their communications already. And if there's a new technology that replaces that, it seems to be rather the same. I think it gets less into these issues of where you're in this quasi-public space and using that for your official communications. I think it's certainly something that, like I was saying before, that the evolution of information just kind of pushes us that way. We've seen it in other organizations or other institutions. One of them is just, for example, the SEC in the last couple of years has changed their guidance on how companies distribute information to their potential shareholders or their existing shareholders. And before, it had to be on your website, or it had to be on a phone call to which everyone could dial into. And now they're saying, no, you can use social media, you just need to tell people that you're using social media. So we've already gone to the step of, our corporations, which make all this money, the government is recognizing their use of these platforms that they don't own, but to make these statements. And so it's easy to see government kind of following in those shoe steps because, so much of our economy, and our politics are driven by business. So business is already heading that direction. Then it's easy to see government doing the same thing. And how that then impacts those platforms could be another, issue, but I don't know. The platforms may like it at first because it'll drive more usage to them, but then they may ultimately have their hands tied in some of their abilities to innovate or to change things if things go bad. Not sure.
Yeah, I think the only thing we could really, I could think of right off the top of my head is, for example, let's say Facebook allow government pages to turn off commenting, to where again, they don't allow the private speech to be spoken at on the government webpage at all, the Facebook page at all. That might be a fix, but I think there's some dangers to that. I don't know if Facebook would go for that. When you think about social media, in an ideal world, it is a great tool for democracy. I don't think there's ever been a place where the government and private citizens can interact, right? Think about, before social media, well, you could write a letter to your senator, which is going to get tossed in the trash. It's not going to be seen by anybody else. You can go to a public comments section at a city council meeting. I'm always reminded that I'm not a big TV watcher, but my wife got me to Parks and Rec, and every time I watch it, you see the citizen government interaction. It always cracks me up. But that's kind of what social media could be, right? When you have constituents interacting with the government officials respectfully, ideally, and not being trolls and just going on there to make fun of their government officials' weight or marital affairs or whatever else is going on, it's that democratic tool that's really great. So, how do we sort of promote the democratic enhancement functionality that social media can provide? And what, like Ryan was talking about earlier, curb the hate speech, curb the non-valuable speech that seems to be pervasive on social media, and especially on government social media pages.
Or even non-citizen speech. Like so if you're in Pawnee, Indiana, and you're having a city council meeting, you don't really care what your sister city in Venezuela has to say about your policies, right? I wonder if the way to move into that direction would be like sort of a verification platform for everybody, right? Like that way you're talking to your citizens and whose vote to count.
Right.
So I mean, but like one of the reasons like it seems that free speech is so prevalent on the internet is a little bit of the anonymity, right? You're able to say things that you wouldn't maybe say in public, right? Like I know sometimes people in law school feel like they're sort of a lone person with their political views compared to all their classmates. So they might not speak up as much as they otherwise would.
There's a lot of interesting articles, of course, around anonymous speech and the value and importance of it. Almost all of which was written before the rise of social media, where back then anonymous speech was difficult to reach an audience, but it had some important contributions to our formation as a country. Right, some of the most significant literature to spark the revolution was anonymous speech. So of course it's in our DNA, our political DNA, to protect that. But that was when it was the exception, and now it's the rule. Because there is nothing outside of the slim verifications that Facebook and Twitter does. There is nothing that makes you create your own page, right? Use your own name, even for platforms that require it, right? Like Facebook requires you to use your own name. But they have no verification process except for some of the celebrities. That's why like William Shatner got his account banned a couple times because they thought that wasn't him, and he had to prove it was. So, but now that it's the rule and not the exception, and we haven't come up with these ways of dealing with how communication has changed because of that, it causes all these other problems down the road. And, this is just one of the conflicts that we're facing in terms of political speech, but we'll see others.
So we've got about 5 minutes left. 10 minutes.
Yeah, we got 5 to 10.
Before this angry mob storms the room and
Before the one else come in and type in.
get on Twitter.
Yeah. Very important that So you've mentioned the Knight Institute case and what you think is going to happen moving forward. Do you foresee sort of an end note? What do you think is going to be? Where do you see that case going essentially? And do you think that it's going to spark follow-on litigation, or is this going to be something like what you mentioned, where this decision is important because of the state of technology right now, and it might not be as important in a year or two?
You're the expert on First Amendment, so.
Far from an expert.
Oh, yeah.
I'll do my
This
best. I don't know where it's going to go. I mean, I think, as Ryan pointed out, I think the judge is pushing the parties to come to a resolution here. Mute, don't block. It achieves the best of both worlds for plaintiffs and Donald Trump. But, I think the Knight Institute is certainly in this for the long haul. I think they view this as a test case, and they want to push us as far as they can, and sort of shape how government officials can use social media. It's not the first case of its kind. There have been, other cases litigated and that are being litigated right now, with, citizens being banned, blocked, having comments removed from Facebook, Twitter. But this is the high profile. This is the one people are going to pay attention to. So I think the Knight Institute's probably going to push it and kind of see what happens with it. It'll go to the Second Circuit. We'll see what happens there. I don't know if, I sort of agree with Ryan. I think the Supremes probably want nothing to do with it. Simply because the facts of the case are so wishy-washy, and I think the way Twitter works makes it necessarily, you have to get your hands dirty and kind of get into the details of how Twitter operates. And I think there's a couple of justices who don't want to do that. So they're probably waiting for something like Packingham, which is a little bit cleaner of a case. I think maybe sort of the next frontier is going to be sort of what I was talking about earlier, the interaction between the government and the private platforms. How the government can sort of rely on the private platforms to kind of protect them as far as policing hate speech, threats, obscenity, those categories. Hate speech is protected, but other kinds of speech that isn't protected. But the line of government still has to abide by the First Amendment. Government. One of the problems is that the private platforms can do what they want, right? They can remove any speech they want. They're private entities. The government can't, right? So the government is going to have to try and kind of find its niche on these platforms in terms of abiding by the First Amendment, but still able to reach your constituents. And I don't think the government shouldn't be on social media. Ryan said it's essential these days. That's how you have to communicate. But I don't know how they're going to do that without running afoul of the First Amendment often, just because they're bound by it. And the First Amendment, over the past 4 years, has been broadened to protect all kinds of speech. So it's going to be interesting to kind of see, I think, not only the courts, but just how the governments react in sort of shaping their pages, how savvy they get, sort of creating their own terms and conditions for use, Facebook or Instagram or Twitter or Reddit accounts. That's going to be what to watch. You see the government get more savvy with the technology, and legislatures as well. I mean, we have SESTA, FOSTA, all these kinds of reactive legislation coming through that's just not really well designed in terms of technology in mind. So I think those two things are going to be what we're going to have to keep an eye on over the next couple of years.
And I think my bold guess is judge rules in favor of 9 Institute, Second Circuit affirms, Supreme doesn't grant cert. There it is. If I got it, I look really good.
It's on tape.
I have a quick question. So I guess there's business accounts on Twitter, right? Mm-hmm. They're business accounts, or they're government accounts on Twitter. So then why don't you use that as like the standard of this is a personal speech? Like I think you definitely have to separate the accounts. Like Donald Trump would have a personal account and a government account, and I think government accounts should be treated as public forum, like you're saying.
I think a lot of the trouble comes from the fact that he does have a personal account, real Donald Trump, and a government account, POTUS 45.
But he kind of just started
He
using
likes the fact, it seems that he wants to reach a larger base of users, and his personal account has more followers, and so he's got a bad habit of making official pronouncements.
Yeah, when we
all
have
over
this
them.
system of private citizens becoming government officials, what happens, especially when one doesn't really think about the consequences of their speech. It just kind of throws things out there.
Didn't a couple of people get notified that they were fired through Donald Trump's Twitter account?
Yes.
His personal Twitter.
Yeah.
I
Just today. So, no.
Really?
Yeah, totally
believe
believable,
you.
right? Yeah.
It kind of reminds me of the separation of like the person and the corporation, and like piercing the corporate veil. It's like you should judge it based on the actions of the person. Like if he's using his government account for personal purposes, then I think it should default to being personal.
That would have worked.
That's what I'm thinking.
Yeah, and I think that's sort of what the Knight Institute is saying is look at what he's doing. Don't
Look at the behavior, not the label, I guess.
Well, thank you so much, Professor Garcia, JT Morris. Thank you so much.